Matter of Aungst v. Family Dollar.
May it please the Court, Corey DeCrescenza, Cohen Vaughn, appearing on behalf of the appellants. I'd like to reserve 3 minutes for rebuttal time, if allowed. Thank you. Before we get going, I'd just like to, at first, I'll defer point 2 over brief on the issue of consequential stroke. I think that's soundly within the Court's discretion to review. I don't think it needs significant treatment here. The primary issue for me is whether or not the prevalence standard of review was both properly created and or applied.
I'd like to get your primary argument on that prevalence. Is it that, is it a causation issue or is it a time definiteness issue?
Primarily a causation issue. My position is that essentially the Lerner standard for reviewing disease cases should be the one that applies, and that the prevalence standard, which, to be honest, I'm not even 100% sure why it was created when we had the Lerner framework, that kind of abrogates the first prong of Lerner.
So if it is causation, why isn't it enough to show that the person had minimal contacts with people outside of work, and then at work had significant contacts?
Well, I guess what kind of contacts are being discussed are important. I think there's definitely been some cases where you've shown, an individual contact where a person is the second person to get COVID in the workplace. People were coughing on them, something of that nature. I think just significant contacts with the public, I don't believe that is enough to meet causation. I believe that's too speculative under my ed.
But we've said that we're not requiring people to pinpoint exact exposures, so how do you square that?
Well, I guess I'd square that with focusing on Lerner, which requires inception of the disease must be assignable to a determinate or single act. So
your argument is, despite the fact that COVID was everywhere, this particular person had a job where they had contact with the public, unlike others, couldn't isolate because they did go to work, and there were people who did or did not honor covering, distancing, etc. They still have to pinpoint exactly who they got it from? I don't think pinpoint an individual person is required. I think that's what exactly would work for you?
I guess evidence that I think Williams was a case that came afterwards where it was a transit city worker who people were unfortunately coughing all over this gentleman.
So they have to establish that people were coughing?
I guess evidence that someone is at least sick around them
But some people are asymptomatic.
That's true.
So how do you prove you got it from them, even though they could transmit it in that state?
I guess, unfortunately, you're not able to. I would submit that there's no, I think at one point...
and so prevalence isn't a logical way to deal with it then?
No, I think it's too speculative. It allows, or it's too speculative and it doesn't comport with Lerner.
So how's it different from Johansson?
Johansson, I believe, was the smoke claim.
Yeah.
That was, the claimant there was in a sealed office with a broken ventilator, and there was 50 people, I think approximately half of whom were smoking.
Mm-hmm. We don't know which person smoke caused the problem?
We
don't know what day of work the smoke was inhaled that caused the problem?
Correct, but we do have the medical opinions in that case cited that smoke exposure generally resulted in I think it was asthma or bronchitis.
But wouldn't exposure to COVID likewise result in the transmission? I'm not clear how the two are different, the two cases, Johansson and this one.
Sure. In my opinion, Johansson shows a definite. The person there was definitely exposed to smoke.
But where there is a showing of prevalence, isn't the same essential fact established?
I don't believe so. The evidentiary issue in this case all along has been proving where the injured worker picked up the COVID. There was no showing of any coworkers that had it, which is
But by demonstrating, I think there's an argument that by demonstrating that there is not some likely source of transmission outside of the workplace, what's left? The workplace.
Well, I guess in this particular claim, the claimant was also attending medical appointments, which I know there was testimony that claimant was masking or social distancing, but Dr. Sawyer even testified in this file that doctors...
That seems perhaps like a question of whether a prevalence standard is satisfied as opposed to whether it's an appropriate proxy for something more specific that would require you to identify, including in a window when testing wasn't really available, who it was that was contagious and who it was that infected you.
I guess that's true. I guess I keep going back to the problem is that, we keep discussing prevalence and I guess assuming that, COVID entered the workplace and, it could have been what resulted in Mr. Aungst's infection, but there is just simply no evidence in this case that it was, a patron or a coworker or anyone else.
Why isn't prevalence sort of implicitly baked into Johansson? And let me ask you why, or explain why I ask that. What would your answer be if it had just been one person smoking in the sealed room of 50 employees, or 2 people, or 5 people, or at some point, we get to a point where I think you would say, well, if it was one person who smoked 1 cigarette one day, you would probably say that's not sufficient. We, I think, know that if it's a whole bunch of people in the sealed room smoking every day, that's sufficient. And so why isn't Johansson really implicitly saying there needs to be enough prevalence of exposure to something for us to conclude that the evidentiary standard has been met?
I think this was alluded to in the Attorney General's brief where they try to harmonize prevalence with Lerner, that Johansson, McDonough, Middleton all stand for a reasonable probability of exposure to the incipient event. I think Johansson's different, again, in that there was identified exposure to smoke. Even if, in my opinion, even if there was only one person that was smoking next to the injured worker in Johansson, you still have a doctor's opinion saying, you're exposed for 8 hours a day over however many hours a week, and that resulted in your infection. Here we have a case where, doctors have essentially speculated that claimant may have picked up the COVID at work, but again, I see no evidence that that's the case, and I think prevalence, it just improperly overrules Lerner, which does require some determinate, or not necessarily single act. I think determinate is the better.
But I think in your scenario, the facts really then don't matter, right? Because you're saying, like, if the facts were different here, that this person was using public transit and was on public transit for an hour every day, back and forth to work, and was out at the supermarket and lived in a building with many people that he encountered in the elevator and on his floor and so on, that would be a harder case, I would think. But you would say it doesn't matter because we still can't, in that situation, he probably picked it up somewhere else. But in the situation that we have, where all of those things are not evident, that he wasn't seeing other people, he was using prophylactic measures when he went to the doctor, the only exposure to other people, and the only way you can get COVID is through people, was at work when they were touching him and asking him questions and being face to face with him, and they weren't they weren't wearing masks. Like in your scenario, it seems to be like if you can't figure out exactly that somebody had COVID at his place of employment, then the facts really don't even matter.
I suppose I would tend to agree with that under Lerner. I think that's
Didn't we, in essence, overturn Lerner with Massey and Middleton?
I don't believe so. I think those files all squarely fall within Lerner. I think all those files, even if, there's not a single, again, I focus on the determinate act. There's no single act in, McDonough where the teacher was exposed to mumps. You can't point to, this individual student saying, that's where I contracted the mumps. But we know for sure that claimant was exposed to, that injured worker was exposed to mumps. So I guess I keep going back to, if the facts are that you cannot identify exposure, yes, you do not have a claim under Lerner, and that the prevalence standard improperly sidesteps that. And I do think all of the claimants in McDonough, Middleton, and Johansson were able to prove that. And I guess some of the, I guess, confusion in this area can kind of be highlighted by the cases that followed the briefs in this case, specifically Holder and Pierre. Pierre was established with, there was no discussion of prevalence in that claim. I think that properly, essentially applied the proper framework, and the evidence there was that the claimant was exposed to a breakout in the workplace. I think that's a reasonable fact pattern for establishment of COVID. And then in Holder, the house manager claim, I think they did apply prevalence, but came to the conclusion that there was no claim because there was no evidence of specific exposure. So that's my argument. And the alternative is that even if prevalence stands as a properly created standard review, it still wasn't met here. So that...
Because they couldn't point to anyone who had either the symptoms or had officially been identified as contracting COVID?
Yes, and I think the testimony was clear that there
Well, they
were...
could be exposed to customers that they'll never see again who are sick,
Sorry, do you mean in Holder?
which is
or
the
do you mean-
slight difference between the worker who's in a room with people who are always in that room with them, right, and they're exposed, as opposed to someone who's perhaps exposed to people who come and go.
Yes, I would agree there's a difference in that, yes. So, yeah, at this point, my red light. Thank you.
May it please the court, Laura Etlinger for the Workers' Compensation Board. The court should affirm, because there is substantial evidence in this case, that Aungst's contraction of COVID-19 occurred in the course of and arose out of his employment. And what the board did in this case is look at all the facts and make a very reasonable inference that given these facts, that he was in contact with members of the public on a regular basis, there was a mask policy that wasn't enforced, that...
Counsel, what are the limits on the prevalence rule in your view? Is it limited to COVID? Is it limited to some early stages? Is it a proxy for any, any exposure to any contagious disease?
It's not, what it really is just an inference that the board could make on these types of facts. I don't...
When you say these types, what are you suggesting that's confined to?
Well, there were really kind of three sets of facts in this case. The fact that at this time, COVID was very prevalent in the community. It was spreading rapidly, so that allowed for a reasonable inference that if there are a lot of members of the public present.
But is that true for any contagious disease or just for COVID in your view? I'm just trying to understand what you think the limits of the proxy are.
I think if there were like facts for a different contagious disease, it could give rise to the same kind of inference.
So another global pandemic or, for example, an isolated outbreak of measles, both?
I think depending on the particular facts, if there were a very prevalent outbreak of measles and there were contact with people who it could be inferred would be infected with measles, there wouldn't necessarily be a reason to come to a different result.
Even if it's easy to ascertain whether someone in the workplace actually has the disease? Suppose it's a disease that manifests itself physically in some obvious way. COVID didn't necessarily do that. Would the proxy still apply, or would you have to show something with respect to specific workers to whom you were exposed?
Well, if you were, I just want to make sure I understand, but if you worked with members of the public and there wasn't anybody, I
guess what I'm asking is, does the rule turn on the proposition that it's difficult to ascertain the actual incidence in terms of individuals in the workplace, and if you had a disease where you could tell that readily, would the rule still apply in your view?
Well, we don't view it as a rule, but I think the same analysis wouldn't necessarily apply, because the question here is, where did the exposure occur? And if there is other evidence that points to where the exposure might have occurred, or why it wouldn't have occurred, that would simply be the type of evidence that would either support or wouldn't support the inference.
Would it
Does
be,
it matter for purposes of this discussion regarding the measles hypothetical, that there have always been vaccines available for measles, but at least in the early stages, I forgot how long into the pandemic, but certainly at the early stages, there were no vaccines. Does that matter at all for the analysis when you're thinking about that hypothetical?
Well, I think the question would be, how prevalent was COVID then among the general population, if you're talking about someone who was working with members of the public?
Well, yes, not yes, I've understood, that's the point of the word prevalent. I guess my question is also about a vaccine that would prevent contraction of the disease.
Oh, well, I'm not sure I understand, because whether Mr. Aungst was vaccinated or not wouldn't be very relevant.
But the
because he
majority of people would be for measles.
Well, if the majority of people were vaccinated with measles, I think you would have a hard time showing that measles was very present among the general population.
Well, that was my point.
Yes, that would be the distinction.
would I be wrong to think of what you're calling a prevalence rule as really ultimately just the question on a set of facts that you have, is it more likely than not that the person contracted disease X or condition X? I mean, is that the right way to?
That's exactly what it is. It's simply a set of facts that allowed for a reasonable inference that it was more likely that Mr. Aungst contracted COVID-19 through an exposure at work than he contracted it
So
elsewhere.
along that same question, is the relevance, is it a legal standard, or is prevalence a legal standard, or just some framework that is helping you assess these cases? I'm trying to figure out, is this like a de novo question? Are we looking for substantial evidence?
It's just a substantial evidence question, and the board made an inference from the facts before it, including the facts that the board knew about the virus itself.
So
sounds-
suppose, sorry.
No, go ahead, finish.
So suppose that hypothetical that I gave earlier, and if I said the person was on mass transit for hours at a time and lived in a very busy apartment building and so on, how do you think the board would have ruled under those circumstances?
I think
Would it
that-
have affected it?
I think that would be a very hard case to reach a reasonable inference that the contraction happened at work.
Council, it might have easily happened somewhere else.
If it could easily happen somewhere else, it's hard to make an inference that it happened in one place or the other.
But why would you draw the inference against the claimant?
Well, you wouldn't draw, I mean, it's very
I mean, let's say the inference could be equal in both of those circumstances. Why choose one against the claimant
Well, you
versus
wouldn't.
the other?
Right, if they were, the facts it would be hard to think of facts that are exactly the same. But I think you're right, in that case, if it were exactly the same, there would be less reason to draw an inference, but I'm not sure that it would be reversible error if the board drew it on those facts. Unless the court has any other questions, we ask that there be an affirmance. Thank you.
Thank you.
Good afternoon. May it please the court. My name is Mark Summers, and I have the privilege to represent the claimant respondent Frank Aungst in this case. It's our position that the decision of the board should be affirmed. The question in this case is whether or not Mr. Aungst suffered an accident arising out of and in the course of employment. An accident can arise out of an abnormal condition, and the board is given very wide latitude in determining whether or not there is an accident or an abnormal condition. In this case, we're dealing with a global pandemic involving COVID-19. I would say that this is not the prevalence theory, although it's been introduced as a new theory. I believe that it has been in existence for many, many years. The McDonough case involving the teacher contracting mumps is a similar situation which involved an epidemic of mumps in a certain area. There's no guarantee that although there may be students within the classroom that were showing symptoms that she contracted the disease based on that exposure. It could have been contracted anywhere, but in that case, the court felt that the claimant met the burden of showing that the accident arose out of and in the course of employment. If the court or the board were requiring that a claimant in COVID-19 prove that they were exposed in the workplace, that they contracted it in the workplace, that would be an impossible standard. COVID-19, somebody could test positive for COVID-19 and not be showing any symptoms, so there would be no way for a claimant to pinpoint the exact point of time that they were exposed and contracted the disease. If that standard were put in place, the first person to contract COVID in a work situation would never be able to establish their claim, but the second person would. That would create an imbalance. It would be unfair to the worker, and the board did, in this case, set an appropriate standard as far as the prevalence within the community. The board looked at this case with the common sense viewpoint of the average person and made a determination that it is reasonable to find that Mr. Aungst was exposed to COVID-19 in the workplace. As your honors have pointed out, the facts of this case show that he was in a situation at work where he worked over 50 hours a week during the early period of the pandemic. He was the manager of the store. He was involved in all aspects of meeting with customers, stocking shelves. He indicated that he was on the front line in the store. He would work the register. He was in constant contact with people throughout the day. He was in contact with other delivery people throughout the day that would come to stock the store. And he testified to several circumstances in which people tapped him on the shoulder or physically touched him in order to get his attention to help them in the store. The carrier, what the board found is that the claimant provided substantial evidence that he contracted the condition in the workplace. By doing so, the presumption under Section 2.7 was instituted, and the carrier was not able to produce any evidence to show substantial evidence to the contrary. They were not able to show that he went to places where he was exposed or did not take care of himself. He testified that when he went to the doctor's office gave him a mask. They social distanced. When he went to the store, he was careful to social distance as well. And there was no circumstance, actually in the beginning of the pandemic in March of 2020, the employer did not require people be masked, did not provide PPE for him to protect himself, and yet he was working, helping people throughout the store come in and get the things that they needed during this global pandemic. So it would be our position that this case should be affirmed. Thank you.
Thank you.
Very briefly in rebuttal, I would just, again, respectfully submit that this is not a substantial evidence case. I maintain that the issue of whether or not the prevalence standard of review was properly created and applied is an issue of a legal issue of first impression.
Without prevalence, could an employee ever establish, when they have transient contact with large numbers of the public, that they got it from the public if it's not, if one of their coworkers isn't identified as having the disease? Could they ever establish their claim?
I think in Williams, that case there was. That was the transit officer who people were coughing on during the height of the pandemic that I think could give rise to a reasonable inference that someone had.
You could cough and not have COVID.
That's true. And I guess at that point, it does become a factual question for the board as to.
So why is prevalence therefore unreasonable to use?
Because I still believe prevalence negates the burden under Lerner to show in a determinate, or that there was a singular determinate act that led to the disease. In Williams, the determinate act was people coughing on you. In Johansson, it was people smoking. Here, I don't dispute that there was COVID prevalent in society at large, but just because you're standing outside during a rainstorm doesn't mean you're going to get thunderstruck. I think that's my analogy here is there's simply no evidence that claimant was ever actually exposed to the COVID virus, which is what Lerner requires.
But if there's nothing to suggest there's exposure anywhere else, and you have a situation, as Judge Troutman said, where you have people coming and going that you're not going to be able to track, and that COVID is indeed prevalent, why doesn't that make sense?
I think because...
Once you've eliminated all the other possibilities, you're left with one.
Well, I guess the key word there is possibilities. I would submit that,
Or were there others in the record? I mean, did the record show there were?
Sure. The claimant testified he did shopping occasionally when necessary. The claimant testified he went to medical appointments, which, again, I think is a significant issue when, COVID is prevalent. Presumably they're treating at medical offices. I think there is no way to tell whether or not it's more probable or not that claimant got the virus there as opposed to work or anywhere else, and I think that's why the substantial evidence standard has been thrown around, but I submit that this is a case of no evidence. There's no evidence of exposure to the COVID virus at any point in this record. And I think that's what the Lerner standard requires. And my opinion is that the prevalence standard improperly negates that and essentially allows proof of establishment of a claim without evidence of exposure to a disease. Thank you.
Thank you.